If you're studying for an anti-corruption law exam, you already know it can feel like a total minefield of sections and offenses. So, in this explainer, we're going to cut right through the noise. We'll focus on the absolute core offenses under the Prevention of Corruption Act. You know, the ones that are almost guaranteed to show up on your paper. Let's dive in.
So, let's start with a really fundamental question. In any bribery case, who's the actual offender? Is it the public servant taking the money? The person offering it? Or, hey, is there maybe a third party we need to think about? Well, the law doesn't just lump them all together. It actually creates very specific, distinct offenses for each actor. And getting these roles straight is honestly the key to unlocking this whole topic.
First up, the classic figure in pretty much any corruption story, the bribe taker. In legal speak, this is our public servant. They represent the demand side of the bribery equation, and the Act carves out some very specific offenses just for them.
And at the very heart of the law for public servants is Section 7. Seriously, if you only have time to memorize one section, make it this one. It's the bedrock offense. It covers the act of a public servant accepting or even just asking for a bribe. For your exam, understanding this section is absolutely non-negotiable.
Okay, for an exam answer on Section 7, you need to hit these 4 key elements. The actor, well, that's easy, it's a public servant. The act is critical. It's not just about accepting a bribe, but also obtaining, or even just attempting to obtain, an undue advantage. That attempt is so important. The crime can be complete even if zero money actually changes hands. The intent, of course, links this act to a breach of their duty, doing something improperly or dishonestly. And finally, the consequence, the punishment, is serious. We are talking a mandatory minimum of 3 years in prison.
Just let that sink in for a second. 3 years. That's the minimum sentence. The law is sending a very, very clear message here. This is not some minor infraction. It's a serious crime, and it comes with guaranteed prison time. When you're writing your exam answer, just highlighting that mandatory minimum is a super easy way to show the examiner you really get the gravity of the offense.
This official illustration from the Act itself gives us a perfect, really simple scenario. A public servant just asks for money to do his job on time. In this case, processing a ration card. The main takeaway here? He hasn't even received the cash. The mere act of asking for the bribe is enough to make him guilty under Section 7. This is a fantastic, straightforward example to use in an exam.
Now, Section 11 covers a slightly different situation. This isn't about a direct quid pro quo bribe. Instead, it targets a public servant who gets something valuable for free, or for a suspiciously low price, from someone they have official dealings with. The law sees this as a more subtle abuse of their position, and you can see that reflected in the punishment. It's a bit lighter, starting at 6 months instead of 3 years.
Next, we have the real heavyweight offense for public servants, Section 13, criminal misconduct. This one is way broader than just a single bribe. It covers 2 main things. First, misappropriating property they're in charge of, and second, and this is a big one, intentionally enriching themselves illicitly. This is the section you'd use to go after officials who have assets that are just wildly out of proportion to their known income. And the penalty? It's the most severe we've seen so far, a minimum of 4 years in prison.
Okay, we've covered the demand side of corruption. Now let's flip the coin and take a look at the supply side, the bribe giver. This could be a person or it could be a company, and it is really important to know that the law treats them differently.
For an individual giving a bribe, we're looking at Section 8. The elements are basically a mirror image of Section 7. The act is giving or promising a bribe, and the intent is to influence a public servant. And here's the crucial difference for your exam analysis. Look at the punishment. It's not a mandatory minimum prison sentence. It can be jail time or a fine or both. This gives the court a ton of discretion that simply doesn't exist for the public servant under Section 7.
Now, Section 8 contains a huge potential exam question, a defense for the bribe giver. See, the law gets that sometimes people are compelled, essentially forced to pay a bribe. If you can prove you were compelled, you have a defense. But, and this is the part examiners absolutely love to test, it comes with a super strict condition. You must report what happened to the authorities within 7 days. Miss that 7-day window and poof, the defense is gone. Definitely watch out for this in any problem question.
Okay, so the rules change when we're talking about a company giving the bribe.
That's covered under Section 9. The intent here is specifically about getting a business advantage, but the two biggest differences, the ones you really need to know, are the punishment and the defense. For the company itself, the punishment is only a fine, and its defense isn't compulsion. A company can't really be forced to pay a bribe. Instead, its only defense is to prove it had adequate procedures in place to prevent bribery in the first place. This distinction is just perfect for our comparative analysis in an essay question.
So if the company just pays a fine, does the management team get away with it? No way, absolutely not. Section 10 is designed to prevent exactly that. It effectively pierces the corporate veil, as they say. It states that if a corporate bribery offense happened with the consent or even the connivance of senior management, well, then those individuals are personally liable, and they face the same serious punishment as a bribe-taking public servant, a mandatory 3 to 7 years in prison.
Okay, so we've got the bribe taker and the bribe giver, but there's often a third person in the mix, isn't there? The middleman, the fixer, the agent, the person they call a consultant. Well, the law has a specific offense designed just for this role.
This is all covered by Section 7A. The offense is basically taking money to influence a public servant, either through illegal means or just by selling their personal influence. The key point here is that the middleman is just the facilitator, but the law sees their role as equally corrupt, and you can see that reflected in the punishment, 3 to 7 years in prison. That's exactly the same mandatory sentence that the public servant faces, which really shows you how seriously the law takes the role of the facilitator.
So, we've covered our three main players. Now, to round out your knowledge for the exam, let's just quickly pull together the punishments and look at a few other key offenses you really need to be aware of.
Okay, there are 3 other offenses you should definitely have in your notes. First, abetment under Section 12. This is for anyone who helps or conspires in any of the main offenses, and it carries that same serious 3 to 7 year sentence. Second, attempt under Section 15. This is specifically for the attempt to commit criminal misconduct, which we talked about earlier. And finally, Section 14 targets habitual offenders. If someone gets convicted a second time, the penalties get even more severe. The minimum sentence jumps all the way up to 5 years.
And here it is. This is the money slide for your revision. It lays out all the key offenses that carry those mandatory minimum prison sentences. Try to look for the patterns here. The baseline for most of the serious stuff, bribe taking, influence peddling, corporate connivance, is a 3-year minimum. Criminal misconduct is a step up at 4 years. And being a repeat offender is the most serious, with a 5-year minimum. If you can remember this chart, you'll have the core penalty structure totally down.
So, I'll leave you with a final thought to chew on for your analysis. We know that a corporation found guilty of bribery only gets punished with a fine. But is that really enough? I mean, for a massive company involved in a scheme worth hundreds of millions, is a fine a real deterrent, or is it just another cost of doing business? It's a fundamental question about the effectiveness of this entire legal framework, and exploring it is exactly what separates a good answer from a great one. Good luck with your exams.